Welcome back to Artificially Informed, the podcast series that offers an in-depth look at the Florida Attorney General's Government in the Sunshine Manual 2025 edition. I'm Joel Chandler, and as always, this episode is produced with the extensive use of artificial intelligence. I write the prompts and review and edit all of the output. In today's episode 11, we're diving into Part 2, Public Records, specifically C, what records are covered, application of the Public Records Act 2. We'll be navigating pages 73 through 82 of your manual. Our discussion will cover a variety of record types as outlined in your manual, including adoption and birth records, autopsy and death records, child and vulnerable adult abuse and protection records, direct support organizations, domestic violence and stalking records, drafts and notes, education records, and election records. This episode is packed with details, so it will be longer than our usual 15 minutes. Let's start by looking at some very sensitive personal records. Segment 1, C, what records are covered, adoption, birth, autopsy, and death records, pages 73 to 74. Starting right on page 73, we begin Section C, what records are covered, application of the Public Records Act 2. This section is all about the specific kinds of records that fall under or sometimes have exceptions from the Public Records Act. First up, we have 1, adoption and birth records on page 73. These records are generally kept confidential. The law recognizes the extreme sensitivity of adoption records to protect the privacy of the child, the birth parents, and the adoptive parents. Similarly, while basic birth information might be publicly verifiable, the detailed records are often confidential to protect personal privacy. These records are typically sealed or restricted by specific statutes to prevent their disclosure unless a court order or other legal exception allows it. This ensures that sensitive personal information remains protected. Next, we move to 2, autopsy and death records, also on page 73. These can get a bit complicated as different parts of these records have different rules. First, autopsy reports on page 73. These reports, which detail the findings of a medical examination of a body after death, are generally considered public records. The public has a right to know the cause and circumstances of a death, especially if it involves matters of public interest or safety. However, when we talk about B autopsy photographs and recordings on page 74, the rules change significantly. These are explicitly made confidential by law. The legislature decided that the graphic nature of such materials outweighs the public's right to immediate access, primarily to protect the privacy and dignity of the deceased and their families from exploitation. This specific confidentiality is very strong. Then on page 74, we have C, photographs, video, and audio recordings that depict or record the killing of a law enforcement officer or the killing of a minor, the killing of a victim of mass violence, or the suicide of a person. These types of extremely graphic and sensitive records are also specifically made confidential by law. The intent here is to prevent the re-victimization of families and the exploitation of tragic events. There are usually very strict legal processes for gaining access to these, often requiring a court order and proof of compelling need. This mirrors the strong public policy interest in protecting human dignity and the grieving process. Finally, for this section, we have D, death certificates, also on page 74. These certificates, which officially record a death, are generally considered public records after a certain period of time, though access might be restricted to immediate family or those with a direct legal interest for a shorter initial period. Basic information like name, date of death, and place of death is usually public, but more detailed medical information might be protected for privacy reasons. Segment 2, C, what records are covered, child and vulnerable adult abuse, protection records, pages 74 to 76. Continuing on page 74, we delve into another highly sensitive category, 3, child and vulnerable adult abuse and protection records. These records are designed to protect those who are most susceptible to harm. First, let's look at A, Department of Children and Families abuse records, 3A, on page 74. These are the records created and maintained by the Department of Children and Families, or DCF, when they investigate suspected child abuse or vulnerable adult abuse. A key aspect here is the 1. Confidentiality of abuse records, 3A1, on page 75. Generally, DCF abuse records are made confidential by law. This is a very strong protection intended to safeguard the privacy of the child or vulnerable adult, encourage reporting of abuse without fear of retaliation, and protect the integrity of ongoing investigations. This means the general public cannot simply request these records. However, there are specific conditions under which release of abuse records, 3A2, on page 75 is allowed. These releases are typically limited to individuals with a direct legal interest, such as parents or guardians, or to certain agencies like law enforcement or other child welfare professionals when necessary for the protection of the child or adult or for legal proceedings. The release is carefully controlled to balance confidentiality with necessary access. Next, on page 76, we have B, foster home, licensure, and quality assurance records, 3.B. These records, which relate to the licensing of foster homes, facilities for vulnerable adults, or reviews of the quality of care provided, are also often confidential. The goal is to protect the privacy of the individuals in care and the integrity of the oversight process. Also on page 76, we find C, guardians ad litem and court monitors, 3.C. A guardian ad litem is a person appointed by a court to represent the best interests of a child in a legal proceeding. Court monitors perform similar oversight roles. The records they create in carrying out these duties are often confidential to protect the privacy of the child or vulnerable adult they represent, and to allow them to conduct their investigations without undue interference. Finally, for this segment, on page 76, we cover D, status of abuse records held by law enforcement agencies, 3.D. Even when abuse records end up with law enforcement agencies, their confidential status often remains. While law enforcement has its own set of rules for investigative records, these particular abuse records are typically protected by the same confidentiality statutes that apply to DCF records, emphasizing the strong public policy to keep this sensitive information private. Segment 3, C, what records are covered? Direct support organizations, domestic violence, drafts and notes, pages 77 to 78. Let's continue on page 77 with other types of records. First, we have 4. Direct support organizations, 4, on page 77. A direct support organization, often called a DSO, is usually a nonprofit group that helps a public agency like a university, a school board, or a state park carry out its mission. For example, a university foundation that raises money for the university might be a DSO. Now, while DSOS are indeed related to public agencies and receive public funds, access to their records is actually quite limited by specific statutes. It's not a full open book like other government records. These limitations are designed to balance public accountability with the DSO's ability to raise private funds and operate competitively. For instance, specific statutes like Section 1004.28, Florida statutes for university direct support organizations, explicitly state that certain records are confidential and exempt from public records requirements. This often includes donor identities, the names and identifying information of private donors who contribute to the DSO are typically kept confidential. This is to encourage philanthropy without donors fearing public scrutiny or unwanted solicitations. Proprietary business information, certain competitive or proprietary business information related to the DSO's fundraising strategies, investment activities, or commercial ventures might also be confidential. Trade secrets. If the DSO develops or holds any trade secrets, those are also usually protected from disclosure. Generally, what is public for DSOs are their financial audits and possibly some basic operational information about how public funds are spent. The idea is to ensure transparency in the use of public money without discouraging private support or revealing sensitive business strategies. So it's really important to remember that when it comes to DSOs, while they're tied to public entities, their records aren't as openly accessible as a typical government agency's. Next, on page 77, we cover 5. domestic violence and stalking records, 5. These are records related to incidents of domestic violence or stalking. Due to the highly sensitive nature and the need to protect victims, many of these records are made confidential by law. This includes information that could reveal the identity or location of a victim or lead to their re-victimization. Law enforcement agencies and victim service providers have specific statutory requirements for handling these records, prioritizing victim safety and privacy. This is also where we need to talk about Marsy's Law, which is codified in Florida Constitution, Article 1, Section 16, subsection B. This is a really important constitutional amendment that significantly impacts victim rights in Florida, including how their information is handled in public records, especially for domestic violence, sexual battery, stalking, and human trafficking cases. Marsy's Law essentially grants crime victims a set of specific constitutional rights. For our discussion on public records, the key part is the right to privacy and protection from harassment, intimidation, and abuse. This means that identifying information about victims, particularly in very sensitive cases, is often made confidential in records that would otherwise be public. So, how does this affect these records? It reinforces that information that could directly identify a victim of domestic violence or stalking or reveal their location must be kept confidential. This includes details like names, addresses, phone numbers, and other identifying characteristics if their disclosure would place the victim at risk of further harassment, intimidation, or harm. This creates a crucial balance for agencies, especially law enforcement. They have to protect the victim's identifying information. Public records custodians must proactively redact or withhold information that identifies a victim if its release could lead to re-victimization or harassment under the broad protections of Marsy's Law. This goes beyond just names and addresses. It includes any detail that could indirectly lead to identification. Balance with public access. While the victim's identity is protected, the details of the crime itself, the agency's response, and other non-identifying information may still be public. It's about ensuring transparency of government action without compromising victim safety. Marsy's Law places a strong constitutional mandate on agencies to prioritize victim safety through confidentiality in public records for a wide range of crimes, and particularly for domestic violence and stalking, given their inherent risk to personal safety. Now, there was a fairly recent and significant case from Leon County in Tallahassee that clarified how Marsy's Law applies to victim identity in public records, especially regarding law enforcement officers. This was the Florida Supreme Court case, City of Tallahassee versus Florida Police Benevolent Association, Incorporated, 377 Southern 3rd, 331, Florida, 2023. In this case, the question was whether Marsy's Law allowed the names of police officers involved in use of force incidents who claimed victim status to be withheld from public disclosure. The Supreme Court ultimately ruled that Marsy's Law does not grant a victim, including a police officer, the categorical right to withhold their name from public disclosure. The court reasoned that such a broad interpretation would conflict with other constitutional rights, like the public's right to access public records and a criminal defendant's right to confront witnesses. So, while Marsy's Law provides strong protections for victim privacy, particularly concerning information that could be used to locate or harass them, this case clarified that it generally does not make the victim's name itself confidential if that name is part of a public record, especially when balanced against other constitutional principles of transparency and due process. It means that while sensitive personal details like addresses and phone numbers are protected, the name of a victim in many contexts, particularly where their role is part of public governmental action, may still be subject to disclosure. This ruling helps agencies navigate the complexities of applying Marsy's Law alongside other public records requirements. Moving to page 78, we discuss 6, drafts and notes 6. This is a common question. Are preliminary drafts, working papers, or personal notes public records? The general rule in Florida is that they can be. The definition of a public record is very broad and includes any material made or received pursuant to law or ordinance or in connection with the transaction of official business. So if a draft document or notes are prepared by an agency employee in the course of their official duties and they are intended to perpetuate, communicate, or formalize knowledge, they are generally considered public records. This is true even if they are precursors to a final document. However, the manual points out some nuances. Some notes that are truly personal scratch paper and not intended to be kept or communicated, or certain preliminary mental impressions might not be public records. But once a document becomes more formalized or is shared, it generally falls under the Act. The case of Shevin versus Byron, Harless, Schaffer, Reed Associates 379 Southern 2nd, 633, Florida 1980 is a key case here. It defined a public record as material intended to perpetuate, communicate, or formalize knowledge of some type, distinguishing it from mere rough drafts or precursors. This interpretation means many drafts and notes are public records. Segment 4, C, what records are covered, education records and election records, pages 80 to 82. Finally, for this episode, let's turn to page 80 and discuss 7. Education records. These records cover a wide range of information related to students and schools. First, we have charter schools, 7A, on page 80. Charter schools are public schools that operate under a contract or charter with a school district. Because they receive public funds and provide a public education service, their records are generally subject to the Public Records Act, just like traditional public schools. This ensures transparency in their operations and accountability for public funds. Next, on page 81, we have B, student records, 7.B. These are highly confidential due to federal law, specifically the Family Educational Rights and Privacy Act, often called FERPA, a federal statute found in Title 20, United States Code, Section 1232G. FERPA protects the privacy of student education records. This means that personally identifiable information in a student's education record cannot generally be disclosed without the parents' or eligible students' consent. Florida law also has specific exemptions for student records found in Section 1007.15, Florida statutes. So, while education institutions are public agencies, student records are a major area of confidentiality. Moving to page 82, we cover C, children in government-sponsored recreation programs, 7.C. Similar to student records, information about children participating in government-sponsored recreation programs, like summer camps or after-school programs, may be confidential to protect their privacy. This includes identifying details or sensitive personal information. Also on page 82, we discussed D, school system security, 7.D. Records related to school safety and security, such as security plans, blueprints, or threat assessment information, may be exempt from public disclosure. This is to prevent individuals who might pose a threat from gaining information that could compromise school safety. Specific statutes, like Section 1001.0212 Florida statutes, provide these exemptions to protect students and staff. Finally, still on page 82, we have E, testing materials, 7.E. This refers to standardized test questions, answer keys, and other testing materials used in public education. These are generally exempt from public records requests to protect the integrity and validity of the tests. If test questions were publicly available, the tests would lose their effectiveness as assessment tools. This exemption is crucial for fair and accurate evaluation of student performance. Last for this episode, also on page 82, we look at 8, election records. These are the records related to voting and elections. First, A ballots, 8A. Completed ballots are confidential for a period to protect voter privacy and the integrity of the election process. After an election, They can typically be inspected under strict conditions for specific purposes like recounts or election challenges, but their public release is highly regulated. Then, born voter registration and voter records, 8.b. While basic voter registration information like name, address, and party affiliation is generally public, more sensitive personal information within these records may be confidential. This includes things like social security numbers or driver's license numbers, which are protected by privacy laws. This concludes our detailed exploration of C, what records are covered in the Public Records Act, taking us through page 82 of your manual. Thanks for listening. In our next episode, episode 12, we'll continue exploring C, what records are covered, by focusing on electronic and computer records, emergency records, and financial records, taking us through page 93 of your manual. Until next time, remember, the truth dies in the dark, so let's leave the light on.